Pursuant to Wingfield's definition of negligence, Rosa will hope to succeed in bringing a claim against defendants Tate Gallery, the several churches in London, and Dr. Khan for breaching their legal duty of care owed to her, causing actionable damage. Firstly, Rosa could bring a claim against Tate Gallery and the several churches under negligence for the personal injury of causing her development of lung cancer. Lord Reed and Robinson, Chief Constable of West Yorkshire Police, stated that it was a mistake to apply the Caparo three-stage test where an established category of duty already exists. As such, Rosa can rely on Wilson and English, which establishes employers owe a duty of care to their employees. Wilson can also be used for the several churches, as I believe they are analogously comparable to Rosa's employers. Alternatively, Section 2.2 of the Occupiers Liability Act 1957 could also be used to prove a duty of care exists. We must then assess whether the defendants breached their duty by establishing if the defendants fell below the objective reasonable standard of care. Dicta in Tomlinson and Congleton Borough Council held that the courts embark on a policy balancing act when determining the standard of care. Evidently, the likelihood of contracting lung cancer as a result of exposure to the carcinogen artium is high, and thus the burden for big organisations such as Tate Gallery and the churches to invest in using safer chemical solvents or providing appropriate safety equipment to protect Rosa would be a minimal price to pay to reduce the risk of causing the life-threatening illness of cancer. Breach of duty by both defendants is definitely satisfied. Rosa must now prove that these defendants caused lung cancer both factually and legally. As Rosa cannot prove on the balance of probabilities that there was a more than 50% chance that the defendant's breach caused her harm, the but-for test to establish factual causation, as per Barnett and Chelsea, cannot be used. This is because science is unable to factually establish whether the cancer develops from a single exposure or as a result of cumulative exposure to artium. Rosa's claim would best be dealt with using the material increase in risk test. In Fairchild, the claimant developed mesothelioma as a result of asbestos exposure by multiple employers, and the House of Lords concluded that in some situations, to achieve justice, the but-for test could be departed from. McCaulin was cited to reinforce the idea that this all-or-nothing test denies recovery, while our instinctive sense of justice would demand it. The Fairchild principle was created to provide a cause of action against a defendant who has materially increased the risk that the claimant will suffer damage, when it cannot be proved on a balance of probabilities that some other exposure to the same risk may not have caused it instead. Each of the negligent employers were held to be jointly and severally liable. A more recent case, Sienkiewicz, set the threshold for a material increase to not fall below the de minimis range as extremely low. This will support Rosa in her claim, as the fact that both defendants exposed her to artium for 2 years and above indicates exposure would definitely be beyond de minimis. Although this would make Tate Galleries and the several churches jointly and severally liable, I believe the courts will rely on Barker and Chorus, where the crux of the issue in Barker focused, as observed by Cohen in Fairchild, Gregg and Scott, and damages to Watt, on quantum rather than liability. Here the House of Lords held that liability ought to be apportioned severally based on the time and intensity of exposure rather than jointly and severally. Lord Hoffman's statement in paragraph 17, holding that it had already been established in McGee that whether the other exposure was caused by the claimant himself was irrelevant, also aids us in dealing with Rosa's own exposure to artium. This would mean that as Tate Gallery had exposed Rosa to artium for a longer period of time, they would likely be apportioned more liability than the churches. Barker and Chorus also established, pursuant to contributory negligence, that Rosa's own self-exposure to artium will proportionally reduce the defendant's liability too. Although Section 3 of the Compensation Act 2006 essentially reversed Barker, reinstating the joint and several liability principle in Fairchild, this only relates to mesothelioma claims, so as Rosa's claim regards lung cancer, she cannot rely on this legislation. Although Lord Rogers' dissent concerning how unfairly burdensome apportionment of liability would be on the claimant's suffering is commendable, Rosa's claim is most likely to succeed on the Barker principle of apportionment because it applies to other evidentiary gap disease cases not covered by the Compensation Act. She arguably still has a strong claim as Barker reinstates the relaxation of the but-for test for causation established in Fairchild. It's likely the defendants will argue that because Rosa was exposed to artium and subsequently developed lung cancer rather than contracted mesothelioma as a result of asbestos exposure, the Fairchild but-for exception cannot be used to support her claim. The facts also do not inform us that the other solvents used by the churches are also causal cancerous agents. I would assume that they are not, otherwise the defendants may use the case of Wilshire to argue that when multiple causal agents were used, causation could not be established. In Sienkiewicz, Lord Brown presented in his overture warning that the law tempers with the but-for test of causation at its peril. This indicates that, save only for mesothelioma claims, little flexibility will be given from the courts in their approach to causation. However, I would suggest that Rosa need not be too concerned, as this was only overture, and it is likely that policy principles will favour Rosa. In addition, more recent decisions in Hennigan and Manchester Dry Docks and Zurich Insurance and International Energy Group reinstated that the Fairchild exception extends to diseases like Rosa, which have the similar features of mesothelioma. Rosa must now prove the defendants legally caused her harm. Wagenmount held that the kind of damage Rosa suffered would be reasonably foreseeable at the time of the breach by a reasonable person. As the medical community accepts that exposure to artium increases the chance of developing this cancer, the damage suffered by Rosa cannot be regarded as too remote a consequence of the defendant's breach. Although the defendants may argue that reasonable foreseeability was not obvious, emphasising the rare nature of the cancer, following core and IBC vehicles, the prevailing attitude of the judiciary is to take a broad approach to foreseeable damage in relation to personal injury claims. The second element of legal causation asks whether any subsequent event could be said to have broken the chain of causation stemming from the defendant's negligence. Pursuant to Spencer and Wincanton, to break the chain of causation, the act of the claimant must be extremely unreasonable. As Rosa's lifestyle is predicated on art restoration, it is entirely reasonable that the other victims in her position would be dealing with a solvent like atrium in their spare time. Mr. Khan's subsequent action of negligently misdiagnosing cancer, leading to a lesser chance of survival, is more likely to be an act of a third party which does break the chain of causation. In Robinson in the Post Office, the act of a medical professional will only be a novus actus interveniens if it is unforeseeable. When it is accepted by the medical community that artium increases the risk of this cancer, misdiagnosis is arguably unforeseeable from a breathing specialist. As a result, this does break the chain of causation, which means the employers are liable only up until the point of the break, and therefore aren't liable for the increased reduction in life expectancy. In relation to defences, the defendants will not be required to bring the defence of contributing negligence under Section 1.1 of the Law Reform Contributing Negligence Act for a reduction in damages. As per Barker, liability will be apportioned only in accordance to the extent of the defendant's own contribution to the risk. Rosa will finally want to bring a claim against Dr. Khan for the pure loss of chance arising from his negligence misdiagnosis. Pippin and Shepherd establishes that a doctor owes a duty of care to their patients. Using the test laid out by Lord Justice McNair in Bolam and Fronen Hospital Management Committee, it is arguable that Mr. Khan, through his negligent misdiagnosis, has fallen below the standard of care that be regarded as proper by a responsible body of medical men when considering the medical community accepts that artium exposure increases the risk of lung cancer. However, as the diagnostic procedure Dr. Khan has taken has not been stipulated, it is difficult for me to ascertain whether his practice could actually be regarded as reasonable and logical as per the extended Bolam test set out in Belethio and City and Hackney Health Authority. Assuming there is a finding of breach, Rose must prove Dr. Khan factually and legally caused the harm of a loss of chance of a better rate of survival. The House of Lords in both Hodgson and Gregg employed the but-for test, establishing the burden of proof is on the balance of probabilities, and hence the patients could not recover damages as causation would not be found if their initial prospects of recovery had been less than 51%. The facts of the case in Gregg and Scott are similar to Rose's. As a result of the doctor's negligent misdiagnosis, both claimants' prospects of recovery became nil or almost nil. The decision of the courts when determining whether Rosa could recover for a loss of chance could go either way, depending on whether they choose to focus upon the initial prospect of recovery being within the 51 to 55% chance bracket or the 45 to 50% chance range. If the courts were to consider the exceptionally tight 2-3 split majority in the House of Lords in Gregg and favour corrective justice principles encapsulated by Lord Nichols' dissenting judgment, whereby he regards the way this principle of causation being applied in such an orthodox manner to be irrational and indefensible, this would distinguish Hodgson and Gregg, suggesting Rosa could recover damages. However, the fact that today a loss of chance has not yet been recognised as recoverable in medical negligence claims, it is likely the courts will focus on the 45 to 49 bracket of her original chance of survival to affirm decisions in Hodgson and Gregg. Policy considerations, including the crushing financial impact this would have on the NHS, mean that Rosa may struggle to succeed with her claim against Dr. Khan. As Rosa will likely fail to establish Dr. Khan caused her damage in a factual sense, legal causation will need not be proved and Dr. Khan will escape liability. However, on the basis that Rosa has succeeded in provided Dr. Khan caused Rosa's loss in fact, legal causation will be satisfied, as it is reasonably foreseeable that the loss of chance of survival would occur from Dr. Khan's failure to diagnose Rosa's cancer. There appears to be no subsequent event stemming from Dr. Khan's negligent act which would break the chain of causation. If he is found to be liable, Dr. Khan cannot bring any defences to reduce the damages he will be required to pay. In conclusion, pursuant to the ambiguities within the facts, causation will be a matter for the courts to decide whether or not Rosa's initial survival prospects fell below 51%. Ultimately, Rosa is likely to be able to claim against Tate Gallery and the several churches. However, it is for the courts to weigh up whether they view mesothelioma claims as in a stringent category of their own, or also allow for other diseases which manifest in a similar way. Whether Dr. Khan will be liable for causing Rosa's loss of chance is not as clear. However, Lord Neuberger statement made at a conference in Northern Ireland suggesting aspects of tort law, above all negligence, are based on policy, does indicate, pursuant to Weinberg's principles of corrective justice, that wrong sufferers like Rosa should receive a remedy.